Hi everyone, welcome back to Tokyo on Fire. Today is June 5th, 2018. The Japanese Supreme Court has just ruled that companies may now release employees who have reached a retirement age and rehire them at a different salary. Michael, this is going to cause a real ruckus.
Well, it's not only that they're at a different salary, it's also that their benefits are different, but the job is exactly the same. The only thing that has happened is this arbitrary clicking over, it's past their birthday.
Right.
That they are now 60 years of age, they can be released, they can be retired and rehired. But it was thought that the 2013 new law would guarantee that these kinds of workers, at least, would be protected. Part-timers are paid way too little and are unprotected, that this new law was going to protect part-timers. Mm-hmm. And this was the first big test of this new part-timer law that is supposed to bring parity in what is otherwise a two-level wage and benefits system here in Japan.
With the demographics here in Japan, where a lot of people are getting older and younger people are not getting younger, I don't know if that makes sense, but the number of people who are in the workforce who are beyond 60, 65 years old,
is
who are
growing,
still, and they're still productive, this is a real slap in the face in light of the Prime Minister's proclamation that he wants to include the entire society.
Yes, that's the society of 100 million, that we're all in it together.
What happened to that?
Well, who knows? Certainly, that's the thing. The law seems to be inclusive, saying that there is a disparity, an unfairness between the way that permanent workers, seishain, and those who are contract workers, hiseishain, are treated. It expresses itself not only in terms of wage levels, but in terms of course, national health care, in terms of pension contributions. In this case, the pension contributions are not relevant because these are gentlemen who are over 60 years of age. They're at retirement.
They're going to get their pension.
They're paid out. That was not the issue. And in terms of benefits. Now, in this case, this was two different transportation companies, and indeed in trucking companies, is where the part of the Japanese economy which has the biggest demand for workers right now. If you can drive a truck, you can demand whatever you want right now on a part-time basis. And these workers, partly out of loyalty to their old companies, accepted retirement and then were rehired at a staggeringly lower salary and with far fewer benefits than they had just previously enjoyed. And they sued under a provision of the 2013 law that said, unless there are absolutely unusual circumstances, part-timers hired to do the same job should be paid as much and have the same benefits as full-timers.
Right.
And everyone wanted to, they saw that and they said, okay, how do we test it? Well, this was the ideal case because not only were the jobs the same, but the people doing them were the same. The only thing that was different was the age. And the test was, and the thought was, the Supreme Court, in not the full 15 members, but a petty bench, in this case of 4 members, they would agree that this was unfair. But that was not the way it turned out.
40% of Japan's workforce is part-time. The rest of the people want that coveted full-time position, seishain, because with that becomes in a lot of benefits, a lot of security. You can't really be fired unless you've done something really egregious. That is kind of your safety net.
You've killed the boss, basically. You're very, very much protected.
Right. That's why we have so few employees here.
Yeah, well, the issue is that for foreign investors and for foreign companies working in Japan, this has always been one of the things that they've pushed their embassies and their chambers of commerce to somehow change, because this creates an impossible situation in that you cannot fire anyone. From the Japanese point of view, we are never giving up this, and that's the genesis of what is a two-tier system. With the majority, a slight majority of people very secure and wanting to keep that security, and then what academics call the precariat. They're in a precarious situation. They can be fired. They are paid less. they do not get to have the corporate level of health care. They have to pay a higher deductible. They're in the national system rather than being in the corporate system. Their employers do not top off on their pension payments. This is a feature that the Abe administration has confronted to its credit. And it has had study groups and prime ministerial advisory councils trying to figure out ways to push companies. Now,
crank the economy.
Yeah,
right?
We'll crank the economy, but also get more out of Japan's workforce, because the alternative is to have immigration.
Right.
So
can't have that.
And so how do we get people to continue working, to be working, especially if the current system makes it, there's a punitive aspect for working after retirement. First of all, your pension payments are delayed, and then you get socked with a lower salary. Okay, the argument that the High Court, it was first fought in the district courts, and the district courts found in the favor of the plaintiffs, saying same persons doing same job for the same company, everything should be the same. The High Court then turned around and said, but you know, Japan's, as the argument you made, Japan's percentage of the population over 60 is growing. If those people are going to be paid at their salary, the same salary they were paid at 59, the wage bills are going to just explode. And so the company was okay, and the Supreme Court was then asked to take that ruling and offer its judgment. Now, it agreed in some degree with the plaintiffs in both cases. It agreed largely with the defending transportation companies, saying they were mostly okay in paying lower wages and indeed not giving all the benefits. But in certain kinds of benefits, such as there was a bonus for attendance if you were there.
Safe driving.
These things.
Transportation to and from the office.
These were considered fundamental to the job and were not affected by the fact that these persons had retired. And it's that one fulcrum point that seems to indicate that this entire new law is toothless. Is that the companies are allowed to define what extraordinary, unusual circumstances are. And for them, seemingly, becoming 60 years of age is an unusual circumstance. And that's just, you know, it's amazing. He turns 60. Therefore, we can cut his salary.
Well, to play devil's advocate just for a second, there is a kind of a social contract between the employer and the employee. And that contract consists of, you know, when you turn 60 years old, you're going to retire, right? Everybody does that. So you're kind of out of a job. And everybody knows that. They anticipate that. They prepare for that. When they become 60 years old, they can come back as a different employee. It's up to you to choose, though.
Yeah, but then why did it have the 2013 law at all? And that was the test, to see if the 2013 law could hold up. As it turns out, at least in terms of this particular set of suits, this pair, it seems as though that customary law overcomes the actual letter of the law. And that's the issue that will keep legal scholars busy for a while and trying to figure out, okay, have we come out ahead or behind or what?
Sometimes these issues seem small, but in context, they really are very large as Japan's population continues to get older. Please stay tuned. Hi everyone, thanks for watching. Listen, if you like what we're doing, please continue to hit like, share, and subscribe. If you have a comment, put that into the comment box down below. And absolutely, if you want to be notified of our current uploads, just hit the bell button.